Good afternoon, everyone.
Good
Good
afternoon, Ms. Long.
afternoon.
Are we ready to begin here?
Yes, sir. I think
Yes,
so.
sir.
All right, great. I take it that you've received the agenda as well as the minutes from two of the previous meetings. I think we had a meeting on September the 29th, and we also had one on December the 1st. And
Yes.
and you have those minutes from both of those meetings?
Yes, we
Yes.
do.
Okay.
hmm
Do we need to make any changes or corrections to the minutes of either September 29th or of December 1st?
I didn't see any errors. Um, I didn't pick up any errors. Did
I
you, Ms.
didn't. No.
Okay, well, if there are no changes or corrections to be made to those minutes, we're going to let those minutes stand as they were presented to you. Um, There are several policies. I think there are a total of like 13 or 14 policies that we need to review um, today, and I'm just going to run through them and point out to you what the changes are in each and give you a chance to ask any questions that you may have concerning them. The first one is policy 1-5.1, and this is the school board's non-discrimination policy. And we have inserted identity in place of identification in the policy when referring to the school board's commitment to non-discrimination in regards to gender. So it specifies as relates to gender identity. And we've also included other non-discrimination categories. We've included veterans, and we've added the word information to genetics so that it would be non-discrimination against those persons who have genetic information. And then we've also included the categories of pregnancy, childbirth, or related medical conditions. And this policy change is required by Virginia Code, by the Code of, by the US Code 42 USC Section 2000E that prohibits discrimination based on pregnancy, childbirth, or related medical conditions. And also as provided by Virginia Code Section 2.2-3900 that prohibits discrimination based on pregnancy, childbirth, or related medical conditions, also age, marital status, sexual orientation, gender identity, and of course, the veteran status. And so they are the revisions to the non-discrimination policy of 1-5.1. Do either of you have any questions or concerns regarding those changes to that policy?
I have no questions.
I have none. I just saw it as an expansion of the definitions, and it's my understanding, as I thought I just heard, this is a requirement of the law that we change these to include these the different categories. Is that correct?
That is correct. These
Okay.
categories are now required under federal as well as state law. And so we've now included these categories in your policies.
Okay.
The
Thank you.
next one is your tab 2, which is school board policy 2-2.1, powers and duties generally of the school board. And this is your policy outlining what your powers and duties are. And we have inserted language when public comment through a public hearing is required and when notice is required to the public through newspaper of a general circulation. And the public hearing is required when there is school consolidation, when there is the transfer of instructional or non-instructional services to a private entity, when there is redistricting of school boundaries or the adoption of a student assignment plan that affects 15% or more of the students in the average daily membership. Also, this change in policy relates to the power of the school board to conduct surveys or request the superintendent to conduct a survey to identify critical shortages of teachers, administrative personnel by subject matter, school bus drivers, and then to report those shortages to the superintendent of public instruction and to the Virginia retirement system. This suggested policy revision also ensures that public schools in the school division are registered with the Department of State Police so they can receive electronic notification of registered sex offenders residing within the school division. And then the last change in this policy relates to performing all duties prescribed by the Board of Education. And these changes that are being recommended are required by Virginia Code Section 22.1-79.
I have no problems with either of them.
Me either. Look okay.
All right, let's go to tab 3. There are several policies that are being suggested for revision that pertains to conflict of interest. And this is one of them, 2-9.2. This is the definition section of the school board's conflict of interest policy. And this suggested revision amends the definition of a personal interest and prohibits a school board member from entering into a contract with the school board when the member's annual income in the business, annual salary or fringe benefits in the business, or ownership in real or personal property of the business exceeds $5,000. In that situation, the board member is prohibited from entering into a contract with the school board. Also, the board member is prohibited from entering into a contract with the school board when the lower amount and it has lowered the amount from $10,000 to $5,000. Initially, the amount in this policy was a $10,000 amount. It has now been reduced to $5,000. And that is also required by Virginia code. And that's under the Virginia Conflict of Interest statute. And that statute is found at 2.2-3110.
Now, Mr. Waller, the only change I saw was in the legal authority. Is that correct?
No,
I missed, oh, I see the, and in 13.
right,
I'm sorry, 13 and then the legal authority.
correct.
Okay.
And
It's Mr. Waller.
yes,
Is the amount has changed, the amount of money?
that's correct. It went from $10,000 to $5,000.
Right.
So now
And
if
that-
someone has an interest that is in the amount of $5,000, they are prohibited from contracting with the school board. And this pertains to a school board member.
Right. And the policy already existed, but the changes made in item 13 and in the code, in the legal authority.
That's correct.
Okay, I just wanted to make sure I didn't miss other changes.
Right, they are the changes.
Yeah, I have no problem with those.
I have none either.
Okay. Policy tab 4, policy section 2-9.4. And once again, this is policy as relates to conflict of interest. And it governs conduct by school board members regarding the acceptance of gifts and favors. And what it does is that it expands the prohibition on receiving of gifts. It prohibits school board members from accepting a gift from a person who has an interest that may be substantially affected by the performance of the school board member's official duties, or the acceptance of a gift that raises the appearance of the use of the board member's office for private gain, or using the board member's public position to retaliate or threaten any person for expressing views on matters of public concern. And this change is required by Virginia Code Section 2.2-3103. And once again, this is part of the conflict of interest policy, and it governs the conduct of school board members as it relates to the acceptance of gifts and favors.
Mr. Waller,
Mhm.
I don't have a problem at all with the changes in the policy, but I do have a question because it always plagues me whenever I'm contacted by vendors, as you know, because I always send the information to you, I copy it to you. I always wonder what our responsibility is with regard to, I always send it back to you and tell them to go through our process, because most of the time it's people who want to buy stuff and want me to look at things. But I want to make sure that I'm following the proper procedure by sending that information, by directing them back to the superintendent and our purchasing department. Is that the policy, or that the standard you want us all to follow? And is that in accordance with this?
I do believe that's an appropriate course of action, and I would strongly encourage board members to do that for two reasons. One is you don't want to give the appearance that they can get a favor by going through you as a board member. That's the first thing. The second thing, if it's something that you're later called upon to vote on, and this person has made contact with you outside of the normal procurement process, it may open the possibility of someone to challenge the procurement process because of that outside involvement. So certainly I think you do follow the right process by telling them, I can't talk to you about that. If you're interested in bidding on providing services or goods to Suffolk Public Schools, you need to go through the purchasing department.
Okay, thank you.
The next is school.
I have no problem with.
Okay. If there are no concerns regarding that policy, we'll go on to school board policy 2-9.7, another one of the conflict of interest policies. It carves out certain exceptions to a school board member having a personal interest in a transaction. Keep in mind that generally under conflict of interest, school board members are prohibited from having a personal interest in a transaction that involves the school board. This policy revision carves out a limited exception wherein a school board member can sell, lease, or exchange real property between the school board member and the school board, provided the board member does not participate in any way as a board member, and this is set forth as a matter of public record. In other words, if there was going to be the exchange of property, the board member could not vote on it when it came before the school board, and would have to indicate exactly what their interest is and the reason that they're not able to vote. Also, contracts between the school board and any officer or employee of the school board is allowed to participate in a transaction when the total contract amount does not exceed $5,000 a year, or the contract itself does not exceed $5,000 and is less than $25,000. And the contract was awarded by a competitive process, and the employee made the disclosure as required by Virginia Code Section 2.2-3115. So this is another one of those limited situations in which a school board member could participate in a transaction when the amount of money involved in that transaction does not exceed $5,000 a year, or when the contract amount may exceed $5,000 but is less than $25,000. The employee is able to participate.
Okay.
But keep in mind that whatever the transaction entails, it must be something that has gone through a bid process. And let's say, for example, a school board member turned out to be the low bidder in that procurement process. But those dollar amounts must also come into play in order for that person to actually be awarded the contract.
So if the contract were for 6 years and was for 6 years and it was at $5,000 a year, it would be $30,000. So the person on the board could not bid for that because it would exceed the $25,000.
That's correct.
Okay.
The $25,000 would be the cap for a contract that may cover multiple years. If it's for a single year, the amount could not be more than $5,000.
Okay.
And this change is something that is also covered by the Virginia Conflict of Interest Act, and that's found at 2.2-3110. Any other questions about that proposed policy change?
I have a question.
Yes,
So the state is mandating a change from 10,000 to 5,000 and no more than 25,000 over a period of time. Is that correct?
that's correct.
Does this also apply to other entities in the state of Virginia, such as the city of Suffolk and so forth?
It would, because it's taken from the Virginia Conflict of Interest Act.
Right.
So it would apply across the board.
Okay. All right.
Now, keep in mind that there are certain situations in which a governing body could pass a resolution indicating that it is in the best interest of the governing body to allow someone to continue in a contract with that governing body that may have been entered into prior to the individual serving as a member of the governing body.
Correct.
Yeah, would that also apply if it were like a sole source contract, if the entity was something that only a select group of people could perform, a task that only a select group of people could perform?
Arguably, yes, because in that situation, it could be in the best interest of the public body if no one else could perform that task and it was something that they needed. The next is tab 6 in your book, and it's School Board Policy 2-9.8. And there is no substantive change to this policy. We simply inserted the words "the board member" for policy clarification.
Okay.
But there is no substantive change here.
Okay.
All right.
School Board Policy 2-9.9. Another one of the policies pertaining to conflict of interest. And this proposed policy change refers to the filing of the disclosure statement of personal interest that's filed by board members as a condition for assuming office. That's the statement that you all have to file with the clerk. And the disclosure forms are filed and they are maintained for 5 years in the office of the clerk. And the form must be filed on or before the day before assuming office, or in some cases, employment. And when the deadline for filing the disclosure form falls on a Saturday, Sunday, or legal holiday, the deadline for filing is the next day that is not a Saturday, Sunday, or legal holiday. And the clerk of the school board who releases any disclosure form information is required to redact from the form the member's residential address, personal telephone number, email address, and signature. And this change is required by Virginia Code Section 2.2-3115. Any questions or comments concerning policy 2-9.9?
No,
I don't have any.
no.
Let's look at school board policy 3-1.2, which is your tab 8.
Mhm.
This policy pertains to duties of the school superintendent. And upon request of the school board, this policy will authorize the school superintendent to survey the school division annually to identify critical shortages of teachers and administrative personnel by subject matter and school bus drivers, and report those critical shortages to the school board, the superintendent of public instruction, and the Virginia retirement system. And these changes are required by Virginia Code Section 22.1-79.
All right. I have no problem with that amendment. That addition.
Me either. Looks okay.
All righty. Moving right along, tab number 9, which is your school board policy 3-1.9. And this policy addresses certain criminal acts to be reported by the building principal. And the building principal is required to report to law enforcement incidents of assault and battery, or anything involving drugs or alcohol, threats against school personnel, or carrying firearms onto school property, all of which may constitute a criminal offense. And the building principal is also required to report to the parents of a minor student that such a report has been made, and also provide to the parents and inform the parents, I should say, that they can contact law enforcement for further information. And this policy revision is required by Virginia Code Section 22.1-279.3:1. So basically what this policy will do is when a report is made to law enforcement regarding any of those offenses that I named, a report also is made to the parent of the student to let them know that a report has been made to law enforcement and that the parent can contact law enforcement should they desire any further information.
Okay. Okay. All right.
Tab 10, School Board Policy 4-6.3. This policy pertains to the certification that is required by contractors who perform work on school property and will have direct contact with students. Contractors, they are required to certify that any individual who will provide services on school property and having direct contact with students have not been convicted of a violent felony included in the definition of a barrier crime, or an offense involving the sexual molestation or physical abuse or rape of a child, or any crime of moral turpitude. And the school board is prohibited from awarding a contract for services that require the contractor or the contractor's employees to have direct contact with students on school property who have been convicted of a violent felony included in the definition of a barrier crime, or any offense involving the sexual molestation, physical or sexual abuse, or rape of a child. The school board may, however, award a contract for the provision of services that require the contractor or employees to have direct contact with students on school property during the school day when any individual who provides services has been convicted of a felony or crime of moral turpitude that is not a barrier crime and does not involve sexual molestation, physical or sexual abuse, or rape of a child, provided in the case of a felony, the governor has restored the individual's civil rights. So basically what this change in policy will do is that someone that has been convicted of a serious felony, and that's what the barrier crimes are. They are serious felonies. It's like 160 some odd barrier offenses. When someone has been convicted of a serious felony or a charge that involves molestation of a child or rape of a child, they cannot perform work on school grounds where they will come in direct contact with students.
Right.
If on the other hand, it is a felony that is not a serious felony and one in which their civil rights have been restored by the governor, they can then perform work on school grounds. But again, provided it does not involve the sexual molestation or physical sexual abuse or rape of a child.
Okay. So this would, I know that we have, and I know that it says may, I know that we had a discussion with VSBA with the policy, and we talked about somewhat under the heading of restorative justice for those individuals who may have 30 years ago, even with parents as volunteers and whatever, who had been in a demonstration and might have been in a demonstration and then convicted of a felony for whatever reason, because some people have, whether justly or unjustly, but their rights were restored. They weren't allowed to volunteer or be a part of certain things. So this kind of thing, when it says may, we could indeed decide as a board, not the sexual crimes or any of that, but the other crimes, we could decide as a board whether to allow or reject or whatever, or does it mean we have to or what?
Right.
When it says may.
Right, it gives discretion. It gives discretion. It is not an outright prohibition against that individual. So the board could allow that person to be awarded a contract. And this is something that primarily is going to be happening through the procurement process, more than likely.
Okay.
Because when someone bids on a project,
We are.
goods or services, they are required to provide the certification that no one working for them or their company has not been found guilty of a felony. And so if by chance there is a felony conviction, it would not, under this policy change, outright prohibit them from being awarded the contract if in fact it was not a barrier offense and if their rights have been restored.
Okay. And would it ever, under a circumstance, unless somebody appealed or something, it would never come to us anyway? Under most circumstances, we wouldn't hear it anyway.
Right. Under most circumstances, you probably would not, because it would be something that would happen through the administrative process.
Okay.
And what this policy will do will be to let the those who are involved in the procurement process know what can or cannot happen.
Okay. So this is just to give them some idea of what the parameters are with this, with
Correct.
law.
Correct.
Okay. All right. Thank you.
Your tab 11, School Board Policy 5-2.1. This policy pertains to school crisis and emergency plans. And upon recommendation of the school superintendent, this policy will allow the school board to designate an emergency manager. Each school is required to submit a copy of its school safety audit to the superintendent. The school superintendent is required to submit all school safety audits in the prescribed format to the Virginia Center for School and Campus Safety. And the school superintendent is also charged with the responsibility of creating a school safety audit committee. This policy revision also includes a definition for school crisis, emergency management, and medical emergency response plan. Also for school safety audit, what that means. And it also requires a contingency plan for emergencies that will include CPR, the Heimlich maneuver, emergency first aid. Also, written procedures ought to be in place for emergencies such as fire, injury, illness, allergic reactions, and violent or threatening behavior. Also, space for proper care of students who become ill, written procedure for responding to violent, disruptive, or illegal activities, and written procedures to follow for the evacuation of persons with special physical, medical, or language needs. And this policy is one that is required and is required by Virginia Code Section 22.1-279.8.
Okay.
Are there any questions or concerns regarding this proposed policy change?
I don't have a question about the policy, and I'm sure I need to ask the superintendent. Do we have, or do any of us, I guess, have any knowledge, and I'll ask the superintendent about this. Are we, about my question, and I'm just thinking it doesn't have to do with the policy, but do we have persons in the building who are trained, if the nurse is not actually in the building, who are trained in CPR, the Heimlich maneuver, and so on and so forth? How many qualified people do we have on the staff that are in the building ready to do that? And is there a requirement? I guess this is more policy related. Is there a requirement for a certain number of people per student in the building who are qualified to do that? To conduct any of those procedures?
Right. In terms of whether those individuals exist in the buildings, you're right. I think that's a question that you'll have to pose to the superintendent. I'm not aware of a specific number of people you need in the building. There may be, however, something in the state board regulations regarding that, because oftentimes in the board,
that's what I was wondering, and I was just wondering.
Right. So I would suggest that you may want to ask the superintendent about that, and I'm sure he will know what's in the buildings. Tab 12, regarding lockdown drills. 5-2.2:2. And what this policy does is that it reduces the number of lockdown drills from 4 to 3. And this is also allowed by Virginia Code Section 22.1-279.8.
Okay.
Conduct at least 3 lockdown drills per year.
Per year.
Any,
I don't have a problem with that.
That's the, excuse me, that was the only change on that one, correct?
Correct. That was the only change.
So it just moved it from 4 to 3. Okay.
Right.
Yeah.
Section 5-2.5, policy 5-2.5. This policy requires one additional lockdown drill after the first 60 days of the school year. And each school is required to provide parents with 24-hour notice before conducting a lockdown drill. And the notice is not required to include the exact date and time for the lockdown drill, but just to let the parents know that a lockdown drill will be taking place. In pre-kindergarten and kindergarten, students are exempt from mandatory participation in lockdown drill during the first 60 days of school. Each pre-kindergarten and kindergarten student is to participate in lockdown drills after the first 60 days of school.
I have,
And this
I
is
have a
provided-
question. How do
Yes.
we not let them know the exact date if we have to let them know 24 hours ahead of time?
That's a good question.
Mhm.
I guess what you do, because I was wondering the same thing. I guess what you're doing is that you're not telling them that it's going to happen within the next 24 hours.
Oh,
You just
okay.
give them at least 24 hours notice.
Okay.
So-
So it's at least,
Right.
okay.
So let's say,
It's gonna happen on Wednesday, so we make sure they know we'll tell them Monday that it's
Monday,
gonna happen sometime during the week, or that it's gonna happen.
right, sometime during the week. We let them know Monday, sometime during the week, we're going to be having a lockdown drill. But we don't tell you the exact date, nor do we tell you the time.
The time. Mhm. Yeah, I just wondered, because I thought when I read that, it's like, okay, what does that mean? All right, okay.
I thought the same thing when I first. And then lastly, school board policy 5-4.4. And this policy pertains to student conduct on school buses. And what we're doing here is that we're deleting the first sentence of subsection B. And the reason for that deletion is that in subsection C, it points out that the bus driver is responsible for maintaining the orderly behavior of students on the school bus, and the bus driver can report misconduct to the student's principal. The deleted language limited reporting to serious disciplinary problems.
Mhm.
So that a bus driver is not restricted in only being able to report serious disciplinary problems, we deleted that line so
Right.
that the bus driver can report any misconduct.
Right, right.
It may not rise to the level of a serious disciplinary problem, but the
Mhm.
bus driver can still report it if it's misconduct.
Mhm. Okay.
Yeah, I've seen the flag up and I said, well.
And there are all of the changes thus far in the proposed list of changes in this booklet that you have received. And if there are no concerns about any of those, we will prepare those for first reading at this month's school board meeting.
I don't have any more questions. I don't have any more questions with regard to the policies and the changes that have been made. I realize that they are a reflection of the laws that have been changed. So in truth, we don't really have a choice as to whether we change them or not. They're a requirement. And I think we need to move forward. I would agree that we need to move forward with them to share with the board. So I don't have any issues with anything that we've done.
I don't either. First reading is appropriate.
Well, with that in mind, we will do just that. We will prepare all of these policy changes for first reading, and we'll do that at this month's school board meeting. We have our next policy review committee meeting, because we're now doing these meetings quarterly. I don't have in front of me the date for the next one. Ms. Davenport, can you tell us what that date is?
I believe it's April the 6th, I believe. I don't have it in front of me right now, but I think that's what the calendar said.
And it's going to be this close to this one because we moved the one in January or February.
Mhm.
Right.
Move the one in February.
Okay. Any comments by either the chair or the vice chair?
Well, I had worried.
I don't have any. I think that if there, and you know, one of the things I just want to make clear is to other members of the board or anybody else who's listening, I understand that one of the advisory committees, the SEAC advisory committee, had some extra information they wanted to share with us or felt that they didn't get an opportunity to share with us with input for whatever reason, I don't know the reason, on the restraint policy. We always review policies. We can always set up a call meeting if it's not for the regular meeting. So if people want to give input with regard to a policy and they feel that they have not, it's not too late to give input, and the board will consider if there's some substantive input and there's something we need to look at. So I want to make sure that people understand that it's not, if we don't get it today, the door is closed and you can never say anything else about it. Because I think there was some type of misunderstanding earlier.
And that is correct. Keep in mind that the reason you have a first and second reading and it's listed as an agenda item for your school board meetings is to allow the public an opportunity to comment on any proposed policy changes, or for that matter, any new policy that the board is considering. So when this policy appears on the agenda for the March meeting as a first reading, any member of the public who wants to express an opinion about any of these changes can certainly appear at the school board meeting during the comment period and make their comments known.
And thank you. I appreciate that because like I said, no one spoke directly to me. This is rumblings from some members of the community through back doors rather than front doors. So I just want to make it clear that people do have an opportunity. We have never not allowed public input on matters of concerns, and we publicize those things. So thank you so much for making that clear.
And I can say this also in reference to the restraint and seclusion policy. The director of special education, special programs, she's been in contact with me. And so she may at some point be providing me with feedback either from SEAC or on her own concerning any policies that may impact children with special needs. So hopefully there is a mechanism in place whereby we will be receiving comments from SEAC or from those associated with SEAC on policies that impact children with special needs.
Absolutely. And you know, we do have our advisory committee reports. And at that time, if something has not come up that's urgent, or if they don't want to speak to it, if somebody doesn't want to speak to a specific policy, at the time that they do the annual report and presentation, that's also a time for any advisory committees to give the board input. As a matter of fact, that is the time to give us input with regard to any kind of issues any advisory committee would like to bring to our attention.
All righty. Anything else from either one of you, Chair Dr. Brooks Buck or Vice Chair Phyllis Byram?
No, I don't have anything. Thank you, Mr. Waller.
All right. Well,
I don't
thank you.
give a thing. Paul and
Yes,
Ms. Davenport, appreciate it.
Yeah,
Yep.
and I see her raising her hand. I know she has something to tell us.
Right, I did check, and the next meeting is April the 6th.
April 6th. Okay.
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 All righty. Well, thank you all so much for this afternoon. I hope you all stay safe and well. And we'll do this again on April the 6th.
Okay, thank you.
All
Thank
right.
you. Thank
Okay.
you.
Bye now.